Can we sit down and get started? Because we want to keep things moving. All right, so I'm so glad that we're all here to talk about judicial reform and so on. I will introduce our panel left to right. We've got Sherry Johnson, who did her undergraduate work at University of Minnesota and then got a law degree from Yale. We have Kevin Claremont, who went to Princeton and then went to another school on the Cambridge River. I forget the name of it, Harvard. And then I went to Cornell twice. I couldn't learn from my first mistake. Mahika went to McGill and is a Cornell law student also. You're going to see a pen. Brendan is at Cornell now and went to Cornell as an undergraduate. And Richard Benzel went to the University of Chicago as an undergraduate and then came here for his PhD. And he's probably one of the few people I voted a degree for. So there you go. And this is a very opportune time because many people in this room are staying until midnight last night filing comments on the judicial system. And we may be hearing something about those comments during the course of this meeting. They're supposed to release their final report before the end of the school year, and then those changes, whatever they are, haven't helped them, will take effect June 30 and July 1, and we'll have changes to the campus code, the student code of conduct. By way of background and history, very briefly, this all started when the university opened in 1868, and before the opening, the Board of Trustees commissioned Andrew Dixon White to write a report about the plan of organization for the university. And he did such a great job with that plan or report that as soon as he presented it, they voted to make him the first president. So this was even before he became president. And one of the more controversial and interesting questions he discussed was what to do about campus conduct, because a lot of schools that time were church-based, and so the discipline of the church sort of covered any student misadventures. Others left it with the central administration, but his report argued that it would be really a good idea to keep the administration out of it and let the faculty handle it, because the faculty and the students would then have to interact and they'd work things out, and it turned out to work pretty well until 1969. And at that time, they transferred it from just the faculty to the University Senate, which was a joint student, faculty, employee group. They had a couple of voting alumni members too. And they administered it. The Senate became the University Assembly, and they had control over it until the trustees voted in December of 2020 to remove it and give it to the Vice President for student and campus life. And so we've been under that new 2020 vision for 4 years now, with a lot of experiences that you people can share about. And now this is the first time they've allowed a comprehensive review, which, as I said, the comments were due last night. I think the first thing I'd like to do is turn to Professor Richard Benzel, who's been extremely active not only in the University Assembly, but also recently in the Faculty Senate, to talk about the Faculty Senate actions on the code this year.
Thank you, Bob. I serve on the Faculty Senate. I'm the faculty senator from the Department of Government, and I've served on the Faculty Senate now for about 10 years, so a long history. In the fall, we meaning an active group in the Faculty Senate, put together a resolution on interim suspension, and ran into some difficulties with the leadership of the Faculty Senate and the University Faculty Committee and so forth, and it was delayed. But when we finally passed it, it made two primary points. One was that the way the student code of conduct was being revised should be scrapped. And instead, a committee elected, democratically elected, by the faculty senate, by the student assembly, by the graduate professional and graduate student assembly, and the employee assembly, and the university assembly, all electing 3 members to this committee that then would revise the student code of conduct. The primary reason for that was we believed, and we still believe, that the committee for revising the student code of conduct was basically appointed by the central administration, and they had a strong, very strong reason to validate their own actions over the last couple of years in prosecuting freedom of speech and protest. So that was one of them. The second, and we expected, or not directing, if this committee were to be appointed, democratically elected, we would expect that committee to disentangle the administration of the student code of conduct so that the central administration did not control all aspects. Right now, under existing procedures, the central administration controls the police, they control the adjudicating system, they control the prosecution, they control the appointment of the hearing board, and the hearing board officer, which acts as a judge, is all consolidated in the hands of the central administration. So we would like to go back to what had been initially, up until about 5 years ago or so, a separation of the prosecution, meaning the administration, and hearing of cases from the central administration. So those were the two main points we made in our resolution. It passed the faculty senate by a vote of 80 to 16. It's overwhelming. Similar resolutions were passed by the student assembly and by the university assembly under David Bateman's guidance. I've had a number of resolutions that are similar. Of course, this is not what the central administration wants to see happen. And so their reforms, such as they are, will continue the consolidation of these kinds of controls and powers under their authority. So in response to that, after seeing the preliminary report of the Central Administrations Committee, we have put together a second resolution, which is now pending in the Faculty Senate, repeating those two primary, we don't like to call them demands, it's not quite polite, but that's really what they are. More than recommendations. That is now pending. It's been delayed again by the University Faculty Committee. It's very difficult sometimes to get resolutions that are not approved by the central administration onto the floor of the Faculty Senate. But we suspect that when we do have that chance, if we pass it again.
Thank you. Professor Claremont, do you want to add to the history, particularly explain to us why Cornell does not have a speech code?
I like the historical approach there. The real developments came around in 2008 when I was called in by the then president of the university, who said that the code should be rewritten because he wanted more convictions. And that's sort of a job thing for the president to say. It was private, of course.
But he wasn't a lawyer.
No, he's a medical doctor. But I resisted that. I resisted it. And then came the Title IX developments, splitting off part of the campus code into the new Title IX office. And they worked and worked and worked throughout the 2010s up until this revolution in 2020 when they changed the whole system from a shared governance idea to this system that is everything confined in the central administration, the judge, jury, executioner, etc. Now, I just to interact with Professor Benson there, you don't really think that you're going to have any effect if this resolution gets adopted, right? I mean, this is you're stepping in front of a train here, and I mean, nothing's going to change.
That's a question.
It's a question with my answer, yes.
I will say tenured professors are like Superman. Their job is to step in front of speeding trains.
We've been doing this for some time. We've you do win some things. Dina Ginsburg was prosecuted under this new regime. And she made I may know this, but I'll give you some of the background. She made a 7-second protest at a public event.
A Hebrew outburst.
And when she was done, yes, in Hebrew, it was textual, it was extremely both heartfelt and intellectually informed for 7 seconds. She made the protest and then left the hall.
Unescorted by the police.
And those details are important because the police claimed they dragged her out of the hall. That wasn't true. She walked out under her own steam. But anyway, she was prosecuted by the central administration. She was accosted in the hallway. She was placed under arrest, asked for her identification, which she refused to do it until they'd arrested her. And this was March of 2025. And then from March, she was interim suspension, meaning she was basically Christina Liang, who's not here. But Christina Liang had decided that she was a danger, I don't know the exact words, but a danger to the Cornell community for her 7-second protest, and that conditions under an interim suspension were to be imposed on her. She was a very brave person, and she's a graduate student in ILR. Very brave person and very stubborn. So she refused to agree to what Christina Liang, sitting in one of these chairs, calls restorative justice. Restorative justice means that the full weight of the central administration comes down on you, and you either agree to be convicted under lesser terms, or they'll throw the book at you. And that's what they did.
Someday in the future.
Someday in the future, which was, as Bob is implying, it took almost a year from the interim suspension from the event to a hearing This was in
March of this year.
yeah, March of this year. It was like 333 days afterwards, and then there's another 2 weeks or so when or another week or so when they were deliberating. They acquitted her.
The hearing panel acquitted her.
The hearing panel, well, no, that's not the central administration, but the hearing panel acquitted her. So for a year, Christina Liang, acting for the central administration, had imposed punishment that the hearing board felt was at least inappropriate or wrong. So we do win some things. This was a really big thing in the faculty senate, and we talked about it. We went through the details of the case and so forth and so on. That isn't the only case that Christina Liang had lost. She lost an earlier one, Mitch McBride's case, which was some years earlier. She's a very aggressive prosecutor, and she does take the central administration's interest to heart.
Okay, well, that wasn't my point. My point was that this is not a recent development. They've been working on this for decades to move it out of a shared governance approach to the university running an administrative process, and that a faculty senate resolution isn't going to derail them. The suspension that you're talking about is a very serious problem under the current code. You can't get them to change their basic approach. I think what you have to do is try to amend the code. The emergency suspension is in law called a preliminary injunction. And the preliminary injunctions have this incredibly dark history in America. They were used to break strikes and pretty much derail the labor movement. And then afterwards, they were used to try to derail the desegregation. The idea is it comes before a judge, the judge all by himself or occasionally herself, would give the injunction, and the whole thing would be decided by the preliminary injunction. Well, that's what can happen under the current code. The time comes now to push for amendments to the current code. The law, in its attempt to control preliminary injunctions, decided that what they needed was procedure. That you can't come up with kind of a substantive rule of when you can use emergency suspensions. The situations vary completely. And so you need procedures. The procedures are just totally lacking in the current code. For one thing, there's no standard given. There's no standard under which emergency suspension can be proclaimed. If they had a standard, and the law has developed one, it would be useful to look at that. If they had a standard, then the decision maker has to justify what they do in light of the standard. You can't just have an explanation, well, we think a emergency suspension is needed. You have to justify it by applying the standard. Another thing is that the Constitution of the United States requires a hearing. Well, not us. We don't have a hearing. In fact, the hearing requirement comes in a case involving students and schools. And the idea is that you've got to, before you put an emergency suspension, you have to tell the student what they did wrong and give them a chance to respond. It doesn't have to be a full-fledged. In an emergency situation, you can go pretty fast. But there's a right to be heard. Appeal. You need appeal to sort of a neutral body. Well, they are going from an appeal just to the vice president to a panel of 3 pros. That's not really, an appeal. What you need is an appeal, as it was under the old code before 2020, where you went to the hearing board.
The review board.
The review board. You went to the review board. Well, that could still be done, but the important thing is to get sort of neutrals to observe that. But I think that's what has to be done now, is coming back at the administration and pointing out that what they're doing is really lawless, and that we can adjust the code. I don't think there's much hope for pricing resolutions saying, well, we wish we were doing this back like we did back in 1868.
Could I ask Professor Johnson a question? There are two key elements to the U.S. criminal law, and actually New York State criminal law, that are very important. One is the idea that when you have a serious crime, they call them felonies, you have to go before a grand jury before you can launch the prosecution. You have to prove to this other group that there's some there. And the other one is what we call the Speedy Trial Act. Both New York and the federal judiciary have a Speedy Trial Act where unless the defendant waives it, you have to try a misdemeanor within so many days and a felony with a longer period of time and so on. What do you say about that, particularly in what you view as what is adequate due process?
Well, one of the problems with not having any sort of neutral decision about whether to bring charges is that if charges are brought, you will have to report that those charges were brought if you want to apply to medical school, if you want to apply to law school, if you want to apply to almost any graduate program, and to some kinds of government employment. So one of the problems is that if you don't have an early screen that determines whether or not you've been charged, even if you're ultimately acquitted, you have to report those charges, and that's damage in itself. And I think that's one of the reasons we have a requirement of a grand jury, is that someone is supposed to be determining whether or not before charges are brought and the whole judicial process comes down, is that there's a cause to do that more than just someone said so. And in the RCC, the Respondent Codes Counselor's Office, we have seen a number of cases in which charges have been brought that people will have to report that they have been charged. In one case, a woman was charged with assault and endangerment for words that she posted on her private social media. She was ultimately acquitted, but in the interim, she was suspended for a semester, and she was charged, so she will have to report that. And so I think the notion of someone reviewing charges other than the single person who decides that would really be a good thing, sooner rather than later, because later both imposes other sanctions, not formal sanctions, but informal ones of reporting, and also can lead to great delays. I think so. I'd really like to see something that happened before charges are brought. I think the other thing that you asked about speedy trial is one of the consequences for many people, especially people who are graduating, is that we withhold your diploma if you have pending charges. And withholding your diploma puts a huge amount of pressure on people to come to some sort of alternative resolution, to really admit their guilt in one form or another, because of course, if you're about to graduate and you have a pending job offer, you can't graduate, you can't take that job offer unless you graduate. That's enormous pressure on people. And so that pressure, you might be charged in the beginning of your senior year or even when you were a junior. And if the process doesn't move quickly enough, you end up thinking, I just need to admit responsibility here because otherwise I'm not going to graduate. And so speeding things up, having some sort of right to determination within a reasonable time period, like a semester, would really be very helpful. And sometimes, of course, the respondent wants to have more time. If they're in a mentally fragile condition, maybe they cannot respond in that amount of time. But speedy trial kinds of provisions actually do take account of that. If the defendant wants to have a longer period of time, that's a different matter than if the administration or the state wants to have a period of time. So I think those would be great changes to the code.
Well, Ms. Mehta, you and your staff have been staying up half the night filing comments last night. Do you want to, first of all, share any comments about what you've heard so far. And I also want you to address specifically the coordination of the student code with the other codes out there, because I understand your office represents students who can be accused of any of those. So we have, the Title IX, Title VI, Office of Civil Rights. We've got the Student Athlete Code of Responsibility. We've got the dorm codes of the individual dormitories. We've got more codes than I know what to do with. So would you like to fill us in?
Yes, I'd just like to add on Professor Johnson's last point about withholding degrees. Another thing that's so problematic about that is that there's no guidance, there's no set list of enumerated factors that are considered when a degree is withheld. It's entirely Christina Liang's jurisdiction. She just makes the decision whether or not and when to withhold a degree. And this is not an appealable decision in any way. We don't know what factors go into it. We've asked for guidance on this in the past so we can better advise our clients, and we're just told that, it's a case-by-case determination. There's nothing concrete that goes into that. So that's also very frustrating, and that is part of the comments that we have made on the code revisions, both now and last semester. And we do work under several codes, the Code of Academic Integrity as well, and we see similar problems there. That one's a little bit different, where it's entirely college by college, so there is just an entire lack of consistency, which also makes it difficult to advise clients because different colleges can handle cases so differently. I don't know if you want to add on to any of that.
Okay. Well, why don't you just spend 2 minutes telling us about your office? I can tell you, because you weren't there, that it really dates back to the 1971 revision. And at that time we had the judicial administrator, and we had a second young lawyer called the judicial advisor. So we actually would hire one lawyer to do the thing. And then I think it was under Kevin's leadership, they converted it into a office staffed by second-year law students under the supervision of a law faculty member, so they won't be arrested for practicing law without a license. So other than that, would you like to tell us about your office?
So our office currently consists of two 2Ls, so second-year law students, and then, three 2Ls and three 3Ls as well. Professor Johnson is our faculty advisor. We work under all the codes that you mentioned, and we provide free and confidential representation and advice to students accused of misconduct under any of these codes.
But is it fair to say that because all these offices operate in such an opaque manner, probably the only 5 people outside the prosecution that knows at least half of what it is are your staff?
That is true. The codes are not very clear. They're also not very detailed, and so they're open to interpretation. That interpretation can change case by case, which is very frustrating. Another problem is that we don't have any kind of precedent. So we're not able to cite to a previous case when we're making arguments in a current case. And the result of that is that the outcomes that we get can be very different across cases.
Well, that's actually a very important point, because the pre-2020 codes specifically had precedents, and there was this sort of notebook that had a case summary of every single case, and with some redactions. You don't know that Joe was a flake when he was an undergraduate or something. And you would go and essentially would say, well, gee whiz, Joe got $150 fine for that specific thing. You shouldn't go above $150 for Sam. And we had a specific debate and fight over whether that would continue. I said that you should write in a provision in the new code that the old book of precedents carry forward. And the administration claimed that since this was supposed to be less legalistic, we don't need precedent anymore. And so we still have case summaries issued by the panel in each specific case, but neither the case summary nor the transcript of the hearing is released and made public unless the respondent chooses to appeal. Brendan, do you have anything you want to add? What were you staying up last night over?
We had all in our office consolidated our comments a few days ago, and then submitted them to Mihika for her review and editing. But I think that a lot of the concerns that we've already covered, inconsistency between cases that have similar fact patterns, inconsistency between the practices of the offices and sort of the plain language in the code. And then I think inconsistencies between investigators and how they apply the code are all concerns that we have in our office and concerns we've raised to central administration and we feel have fallen on deaf ears.
Well, one concern that I have, and a lot of the respondents have expressed to me, them and their alumni friends, is that, you know, if you go to the DA's office downtown, you know exactly which assistant DA is working on this case. And it's sort of like reading a football defense. Everybody's like shifting in the backfield, and apparently they pass cases around. And there have been instances where you ask for a meeting or you send an email and you expect a response and you don't hear anything for like over a week. So how do you, go ahead.
It's actually more like a month right now. There's been a lot of turnover in the conduct office, OSCCS. They're extremely understaffed right now. We've had cases change hands. We've had cases that have gone on for months and months. I have one case in particular that we haven't heard anything in over a year, and we've been following up, we've been sending emails. I've spoken to Christina in person, I've spoken to her over the phone, and we just don't really hear anything about this. And thankfully, the student that I'm referring to, he's not currently under a temporary suspension. But if he was, I mean, it would just be a horribly disproportionate impact. And we have had students who were temporarily suspended and they're asking for updates and they're following up, and they just don't hear anything for several weeks.
Well, you know, if you go to DA offices, even small DA offices, they have all this specialized case tracking software. And even if you go to a large law firm, there's a lot of software. And I always puzzle, like, why doesn't the OSCCS invest in a decent case tracking system? I don't know whether they use, like 3x5 cards or they use a dartboard. What do they do to keep track of who's working on what?
We have no insight into that.
Yes, a question from the audience.
Well, thank you all so much for speaking. Particularly, thank you, Bob, for organizing it, and Professor Johnson for speaking, and Professor Pencil, and everyone really. I think it's just so interesting how, there's nothing really good to say about any of these procedures. I think that, if we were in 1948, any party member under Stalin would be rather proud of this system and might even take some notes out of it. And it's kind of a joke. I mean, she's like Lai Liang. I mean, it's ridiculous. I think it's quite sad that students are going a year without hearing anything, precisely to your point on how, we don't know what she's doing, if she's doing anything at all. And my kind of question is that why would there be grounds for a mass tort action against the university? Because this is really a systemic, horrible and disgusting problem when you have so many people that you could have.
Okay, so the technical question, and my procedure professor will correct me, I'm sure, is that there's a body of case law in New York State that says that when you want to seek review of these sorts of decisions, you go through Article 78 of the CPLR. And that's a very fast-track, rocket docket kind of thing. When people, fraternities, whatever, tried suing universities outside of CPLR, Article 78, under the usual lawsuit stuff, the defending university says, no, you're out of time, you should have sued under Article 78, go pound salt, and a lot of them are dismissed for that reason. There are two things I just said that you must remember. One is anybody in a disciplinary action could go run to any circuit court in this judicial district and file an Article 78 proceeding. So you do have judicial review, even though the code itself says no review. The other thing, though, is that they will assert very interesting defenses when you try to sue them. And Cornell has more than its share of litigation. Did I get the procedures right, Kevin?
Yes, you did.
Okay. Is there another good question from the audience? That was very good.
Would you be able to, does Article 78 pertain to the fact that the code of conduct is technically a contract between?
No, it's not based in contract. It is the idea that any state agency extremely broadly defined cannot engage in arbitrary and capricious conduct. And so what you're saying is this classic piece of decision-making is arbitrary and capricious and should be overturned because it's not sustainable. The advantage is there's very minimal discovery and it's essentially like a summary judgment proceeding. You go right to decision. And people have won. The most famous one is Holden versus Cornell, where a group of mischievous Cornell students claimed that the Cornell Board of Trustees was subject to the New York State Open Meetings Act and sued and was upheld in both the district court and the appellate division. That's certainly one that we won. There have been some where we've lost, but that's the way it goes. Yes. Okay, but at least you don't spend as much as you do in a class action lawsuit. All right.
I do want to say there's one thing I will say that's good about the code, and that's in contrast to Title IX proceedings, which is that the code does require a finding of responsibility by clear and convincing evidence. And if we're talking about Title IX proceeding, that's preponderance of the evidence. And if you think about that, either a Title IX finding against a student or a code of conduct finding against a student can really be the end of their professional career. It really is significant that it's clear and convincing in this proceeding. Really, of course, I'm kind of saying in a backward way, it's outrageous that Title IX proceedings have a preponderance of the evidence standard, but I want to say that only because we would certainly want to keep that aspect.
Well, I want to add 2 footnotes to your very wise observation. The first one is that under the student code, if you are a group and not an individual, it's preponderance of the evidence, which I think is ridiculous.
More likely than not.
Yes, so if you are, say, Students for Justice in Palestine or a problematic Cornell progressive or something, they file the accusation against the group rather than the individual, and they don't have to actually prove that any individual did it, whatever they're accused of doing. They just say collectively the group has been convicted by the preponderance of the evidence, and that's very problematic. The other thing that I want to add is this newly renamed Office of Civil Rights, which used to be called the Title IX Office, has 2 different procedural paths in it. One is the Title IX path that was improved in the first Trump administration by the Trump final rule, and the other one was the procedure that preceded that dates back to like Obama Dear Colleague letters, and that doesn't even have an independent fact finder. It has a single investigator model where somebody is assigned your case, he writes up the memo, he does all the investigation, and then he decides whether his work was good enough to convict you, instead of at least going to another employee to make that decision. But I agree with everything you said with those 2 footnotes. Go ahead, please.
So I'm quite unfamiliar with this process. I haven't staged any fun protests recently, but I do serve on the CAL's Academic Integrity Board. And I guess from my perspective, it's a board made up of students and professors, and we hold, appeal hearings for those who committed academic violations. And I guess from my perspective, we have so many boards across the campus and different colleges that have this fair appeal process and a fair process, or arguably fair process in general. So how did this board get so, why is this procedure so improper, and how has it not been corrected, I guess? Because, anyone can tell, I'm a bio major and I can tell this is wrong, right? How has this not been notified by, I guess, the universities? Especially if it's impacting people's lives, like the right to appeal seems just naturally fair process in this case.
There is a statute, sort of a student bill of rights in the New York State law that says essentially that every student has a right, at least one step of appeal on just about everything. So that's a statutory right. But to answer your question specific.
She means not on preliminary measures.
Yes, but even on all measures. So the historic answer before 2020 was there was this University Review Board, the interim suspensions got appealed there, the final verdicts got appealed there, and in fact, even stuff that came out of the fraternity disciplinary system got appealed there. So it was like one group of appeals that hopefully, everybody would respect, okay? Then the 2020 process, I think they took out everything that would be pro-student, and they scrubbed it, like the deadlines. There used to be a 5-day deadline between the hearing panel and when the decision had to be made public. They dropped that. They dropped every single deadline. They dropped most of the things that due process people would like to see. And then that code sat there, and a bunch of people, I admit I'm one of them, spent 3 years putting political pressure on them until finally in August of this year they said, okay, we will have this process. But the process was not what we had agreed upon in 2020. Instead, it was a review committee handpicked by the vice president without it being half student assembly, half graduate and professional assembly. It was just one of each. And then he stuffed it with administrators.
But your point is really good that how can this be? Apparently the central administration really cares about this. This was not an accident. They're overturning 100 years of practice, or more than 100 years, and then installing this new system, which just doesn't seem to pass the outrage test. It is hard to explain, except that apparently something's at stake.
There's like the few core people who are holding on to this, like it's their last hope, and we're all like, this is so wrong, but we can't help it because they're the ones with power.
Well, and for some people, we haven't even talked about the immigration consequences for people, because in one recent case handled by the RCC office, they were adamant that this was an assault, and it was between roommates, and they had lots and lots of evidence, and so they suspended the students, but suspension means that you get deported, and because you're not in school full time. And in the end, there really ended up virtually no evidence, and there was a finding they were completely found not responsible, but they had already been deported.
The only evidence against them in that case was the word of the complainant. The complainant didn't even bother showing up to the hearing. There was only one neutral third-party witness, and the witness completely corroborated the respondent's story. They were deported. On top of that, they both lost $350,000 plus job offers that they just, you can't come back from that in the same way at all. And it was over nothing.
Yes?
Has the university given any reason outside of like blatant desire for consolidation of power for the revision to the code? Because it sounds like it was overall working pretty well.
Well, you have to, that's a two-part question. The first question is what happened in 2020, and the other question is what happened this school year. I will answer 2020, and I'll let the RCC talk about this year. In 2020, what they did was they went to a group of students in the student assembly. We in the university assembly had for 2 years blocked a bunch of recommendations that were felt to be very improper, that had been endorsed by something called the Presidential's Advisory Committee on Diversity, PAID. So they made it sound like it was a racial justice issue, even though it wasn't. It was a due process issue. And then we thought that had been pretty much slowed down, and they then had the university council, who was about to retire, draft up her own code, and got it passed through the student assembly on 15 minutes debate, claiming it was an issue of student assembly power and prerogative vis-a-vis the university assembly. And then there were these two conflicting drafts, the UA revisions that they've been working on for 2 years versus the SA ones that were 15-minute whitewashing the ghost-written document of the University Council's office. And then the president went to the Board of Trustees in December of 2020 at their meeting and said, look, I'm only trying to do what the students want. Vote for this because this is what the undergraduate students want. Don't pay attention to the University Assembly. I think that's a fair summary, don't you, Richard?
It's, even the adoption in the University Assembly, I was on the University Assembly, I was on the Campus Codes Committee at the time too, and we had drafted a revision, the Student Code of Conduct. Everything that Bob said is right. I would just add that it came in at the last meeting of the University Assembly. Nobody had read it. We only discovered in the process that it had been written by the central administration. It had been given to the students, and you'll read at the website for this thing. It had been given as a program for restorative justice. And restorative justice became the key word, and the idea the students who were the carriers in the University Assembly of this draft believed that it was going to deliver to students more influence and lesser punishments and so forth.
And less legalism.
Yeah, no, but the procedure for adopting it, this is one of the things the central administration later tried to correct, was illegal under University Assembly rules because it was a new draft, hadn't been seen, couldn't be offered as an amendment at that stage. It was the very, very end of the school year.
Okay.
And later went through, and I don't remember the details, but in the fall went through another process of legitimating the code because the University Assembly had not adopted it. One of the things is to remember about the Student Code of Conduct and cases is the vast majority of them, my understanding from the records, involve alcohol and substance abuse.
In the dorms mostly.
And it's one of the arguments that's always been made in the hearing, in the statements, reports in the University Assembly, has been that the processing of these cases it's really just a processing. You slap the wrist and move on. And that the problem, that efficiency is what really counted for those, or was a high priority for those cases. The cases I'm most concerned about, and we on the faculty senate have been most concerned about, have been freedom of speech and protest cases. And those are a small percentage of all the cases that come before us. I think the central administration, in effect, discovered recently how useful this revised process is for controlling and influencing speech on the campus. And discovered that wasn't an original purpose.
Well, I do want to give the RCC a chance to comment on the 2026 revisions and where you see that came from, what the rationale was for the proposed changes and what you thought of them.
I mean, about 3 years ago, we almost never saw any temporary suspensions. They were exceedingly rare. They were more common, I guess, in organizational cases, but against individuals, we almost never saw them. And then when the protest activity became a lot more common, we saw so many temporary suspensions. And they were used in ways that were kind of coercive because they would force students into signing alternate resolutions, which is kind of like a plea deal, and accept terms that were unfair, but students felt they had no choice because they had to get back to classes. And I think there was a lot of backlash against that. There was a lot of pushback. We saw a lot in the Sun about that as well. And I think this is, in a way, a response to that, which is why we were anticipating a lot of positive change. And I think we have had some positive change, to be fair, just not to the extent that we were hoping necessarily.
Mm-hmm. The other thing that I think Richard raised that we should talk about for a minute is statistics. And you know, if you were on the board of directors of Jiffy Lube, you would get monthly reports on how many customers and how many oil changes and how fast each one was done and how long the customers were in the waiting room. You would know all of that. You'd be buried in data. And one of the things that Richard and I, other people, tried to do for a number of years was to get that data out of OFCCS. There were regular annual reports at the JA up until 2020, and in fact, for a long time, the JA was appointed for a fixed term subject to renewal. So there was a real analysis. You know, is this a efficient operation, or is this a train crashing in the rail yard? Finally, the faculty senate put its foot down, and Ryan Lombardi came to a faculty senate meeting and gave out the results for the number of interim suspensions, but excluded the groups. And in fact, there have been a large number of groups suspended. Every time a fraternity is accused of misconduct, they're put on suspension first and investigated later. So a lot of the suspensions were fraternities, but it is a very large number, and it wasn't made public. You would think that since the code itself says the annual report is given to the shared governance bodies, that it would be made public. But Christina Lang, when asked, said, I only give it to the vice president and to the assemblies, and it's up to them to decide whether to release it or not. And so that has finally been, the president said that has to be released. Richard, a comment on that?
No, I think that's all right. One of the problems we've had in getting the data, we couldn't get it in the faculty senate last fall. They kept reporting this gross thing, including all the drug abuse and alcohol and inebriation. But it is one of the things that the university does is it withholds information on individual cases and then justifies not reporting the statistics because it's possible by some, I don't know what.
To figure out who it was.
Figure out who it was, determine. And so one of the problems we've had, and then students who are in this process and come out of it really don't want to report it. They see how vulnerable they are to the central administration. So even when and I did this all last fall, I kept asking people who had gotten under interim suspension, give me the details so I can recreate the cases so I can bring it publicly. And they'd come in and they'd tell me their case, and I say, can I report this? And they'd say no. The amount of fear, the intimidation in this process is really remarkable. It's one of the most distressing things about the whole process is that this is a university. The idea that you run it like East Germany is just, it's horrible.
Well, I'm obviously involved in this for free, grab a slice of pizza as you go. I'm involved in this from free speech perspective, and the things that have been showing up on the FIRE surveys of students is a high degree of self-censorship, and people no longer feel free to voice their views in classrooms or to strangers in the lives. Right, but I'll get to you in a minute. And to me, the most important thing I'd like you to take away from this is there's this feedback loop. If you mistreat people for what I call thought crimes, you are going to have a chilling effect on the atmosphere on campus. And there are a lot of thought crimes if you think of it. I mean, this idea of violating the time, place, and manner distinctions. Even the idea of hazing, I could accuse you of hazing or harassment for saying the wrong thing, for looking at me the wrong way, and it would really take a lot of work to incriminate myself. The Clery Act requires Cornell to report crimes by category. And then that in turn is supplemented by the Stop Hazing Act that requires hazing to be reported separately. And the comments that I filed last night made the point that hazing is over-defined. They have a definition that's developed by the Scorton Center in Cornell Health, and it is extremely broad and convoluted that I don't think anyone can tell you what it means. Meanwhile, there's a perfectly good definition of hazing in the New York State Penal Code, and to me, that's what you should use for hazing. You can outlaw the other thing, just don't call it hazing. So we have far more hazing cases at Cornell than would meet the state definition. Yes, I'm sorry for delaying your question.
What incentive does the university have to listen to any of the comments or complaints about the code? Because I just seeing what happened with the referendum last semester and how hard the university kind of fought to suppress that and how they really just kind of kept kicking the can down the road on responding to it. They have all the power, so why should they care what any of us think?
Well, sometimes they do. I mean, I think the free expression limit that's now being imposed on harassment is a response to pushback. And now you can't, I was actually just looking at, you can't be convicted of harassment unless the expression either is meant to be abusive or humiliating toward a specific person or persons, or persists despite, with a reasonable objection of the person being targeted. That's really, that is a positive step. It really is, because harassment was defined and used in very broad ways. Now that's only it's a half measure though in one way, in that assault and endangerment is not limited in that way. And you might think, well, why do you need it to be limited? Because assault is hitting someone or, threatening them. But the university has charged people with assault with them only posting stuff on social media. So, I really think that it's a half measure. It's a positive step. They responded because there was a lot of pressure on the free expression point, but there's a way around it, and they have used the way around it, which is, frustrating.
Well, my problem with harassment is the lead Supreme Court case on this is David versus Monroe County Board of Education, which has 3 tests which have an and between them, and that's governing on student versus student harassment. And for some reason, they go with the non-student test, which has an or. And if you look at the definition of harassment, on the second 2 prongs, they put an or there when they really need to have an and for meeting the Davis test. So our current code does not pass Supreme Court standards. Another question? Yes, sir.
Well, I have first a quick comment on you mentioned the definition of hazing before. And under the definition, and it's occurred in a lot of fraternity hearing cases, asking new members to clean up after an event is considered hazing, can be considered hazing per university expert witness that they've brought into these cases before. And then secondly, I kind of want to go back to my first question. You guys talked about the CLPR 78, but I did a quick Google search, but that's just an appeal. I mean, Ms. Bennett, you mentioned earlier how 2 people lost $350,000 job offers. How is this not a clear case of damages? Why wouldn't they be able to successfully make a tort claim for this? I think that in a lot of the cases, there's clear, definitive damages for almost every instance here.
Well, but I think there's a causal connection problem, okay? I also think that the times that people successfully sue Cornell are in these class action lawsuits. We've had a lot of class action lawsuits regarding financial aid eligibility, for example. And it's very hard to create a class action, in part because no one knows the facts. I mean, unless every one of the RCC clients get together in a huddle and trade facts, it's very hard to put together some litigation like that. I think those are very important factors. Do you see any other reasons about? I mean, it's not like they sign a waiver or anything.
I mean, this is probably a better question for Professors Johnson or Claremont, but in that case, and in other cases that we've had, there has been a discussion of some litigation against the school, and it's never really made it all the way to the end. And there's a variety of reasons for that. It's also just a significant personal undertaking on behalf of the respondents that go through this. Sometimes they just want to move on the best they can with their lives. So there's a lot of reasons why someone wouldn't pursue this further.
The other thing I would like to do is contrast the Title IX situation with the student code situation. In the first few years of Title IX litigation, particularly after they recognized the private cause of action, there were a lot of, if you pardon the expression, men who decided to litigate the allegations of sexual misconduct against them because the cost to them of losing the case was such that it was worth it for them to hire outside counsel downtown. And so there was a lot of Title IX litigation. The Title IX staff at Cornell was not that good. And in fact, we had a revolving door of Title IX coordinators. For 5 years, we had 5 Title IX coordinators. I think that somehow a degree of acceptance or complacency has grown up on the student code aspect, and the absent losing a visa, the amount at risk in the typical student code case is very small. It might crowd for class action litigation, but it really isn't well suited for individual litigation.
Also, you have to remember, let's suppose that there actually had been a good basis for those charges. The fact that someone ultimately says, we don't find him responsible, doesn't mean that it was wrong to bring the charge. So, what you have to do is you have to convince some court that it was malicious or completely arbitrary to do that, and that's just a really, really heavy burden.
Isn't the other problem that 90% or more of the cases are settled through ADR or plea bargaining? And I think that when they write up a plea agreement, they say, we waive all further rights, the litigant.
Well, I don't know about 90%.
What do you think? I mean, throw out a number.
I think if we're counting alcohol cases, 90% sounds
yeah.
right. It could be probably even higher with alcohol cases. In fact, they had so many this past year that they stopped even charging students with alcohol violations. They would call them in for an educational conversation and leave it at that. So that sounds right. But I haven't seen language on alternate resolutions that says anything about,
Oops, I just gave Day Hall an idea. I'm sorry. Yes, Randy.
So I don't understand something. So what happened in 2020 that changed all this? And whose justice is being restored?
Okay, well, in 2020, in December 2020, there was a special meeting of the Board of Trustees, and after a lot of debate, they voted to put this in the hands, they voted to adopt a document that said, among other things, it was being vested in the vice president for student and campus life. Then over the next 4 years, because the University Assembly Charter wasn't amended and kept on saying they had jurisdiction, there were a series of fights between Christina Lang and the Student Assembly, a University Assembly and the Student Assembly, where then they forced a lot of these things to be rewritten.
What gave the trustees the impetus to?
Because they were told they had to pick between this obstreperous University Assembly that had been resisting the PADE recommendations for the last 2 years, or this brilliant new plan that had been approved by the Student Assembly on 15 minutes debate.
What did these pay?
Presidential Advisors on Diversity and Equity or something.
So what did it have to do with restorative justice?
Because they felt that the system that had been existent up until then had emphasized color blindness and you know, the blindfold of justice and so on, and they wanted something that would take into account more the identity group of the parties.
And are those identity groups better served by this particular code?
I don't think so. I mean, if you talk to any alcohol victim, they feel misused whether they're in one identity group or another, I would assume. You know? Yes, ma'am.
So obviously, from precedent, we can't beat them with legal cases. We have momentum in the news every once in a while through the Sun. What do we do? How do we beat them? How do we change this? You know, I just was in Phi Alpha Delta, which is an undergrad pre-law organization. I was helping with whistleblowing for them on them because they had a rigged election, but then also started, you know, silencing our free speech on how we could speak out and called it, you know, hate speech, which was completely miscategorized. So for this, you know, obviously maybe it's not whistleblowing, but how do we go about this? And I guess as students too, we have a little bit more leeway in how we can kind of approach this, if we can approach it at all.
Richard, do you have any advice?
This is for the last, I would say, 30 years at least. That's the time I've been at Cornell. There's been a steady consolidation of authority in the central administration in almost every dimension of university life. And that consolidation is in part, this isn't quite an answer to your question, but it tells you something about it. About 20 years ago, there was a very revealing discussion in the faculty senate over what the university was, whether it was an intellectual community in which there was shared governance and so forth and so on, or it was a corporation. And the corporation, it's clear that the central administration then, and I believe now, see themselves as the controllers of a corporation. So all of the things, like, in fact, Professor Cornell was pointing at the faculty senate, you know, what can they do? Well, not much. But that wasn't always the case. 30 years ago, the faculty senate had no clout. We're left now with this kind of protest. We can make it marginally expensive to do the wrong thing. But can we correct it?
Well, I have a more optimistic answer. If you had gone to the last faculty senate meeting, like my good friend Professor Benzel went to, the other items on the agenda was one, we're coming up with our accreditation review, and there's going to be, the next 2 years, there's going to be a lot of on-campus self-examination, and certainly seditious ideas can be raised during that process. And the other point that I want to make is, if you read the university bylaws in 1970 and read the university bylaws today, the same amount of power is delegated by the Board of Trustees to the university faculty. I think what Professor Benzel has observed is correct, but there used to be a lot more power vested, for example, in the dean of the faculty. When I was a student here and when Kevin Claremont was first hired, the dean of the faculty was a really tough law professor named Norman Penny, and he was just a power to behold. And he was very senior and well-connected throughout the university, and he went to every single trustee meeting and spoke up, and so he wielded power. For some reason, in this last cycle, for the first time, they elected an associate professor who really hadn't been that well established politically in the campus, and so she's been more on the receiving end of it than perhaps Norm Penny was. There's the 3 candidates spoke at the last faculty senate meeting. The voting is ongoing to see who the next dean of the faculty will be, and if that person's a real tiger, maybe you'll get different results or outcomes. I don't know. Yes, sir.
I guess in part, it seems as though a consolidation of power is part of the motivation, but I'm curious if you as individuals have any other hypotheses for why this is taking place.
I would blame it on the federal government. I'm serious about this. Starting with Obama, there were a number of very serious social problems that the government wanted universities to address, but they went about it like in the wrong way. Yes, during the Obama administration, sexual assault and sexual harassment on college campuses was horrible, and nobody's going to defend that. But the way they went about it with dear colleague letters and tightening up the standard review from clear and convincing evidence to preponderance of the evidence and less due process and so on, they thought they were doing the female students of the university a big favor by doing that. I think in the long run that was like fatally flawed, and it's happened more and more with each succeeding Department of Education, and the principle of the university's self-governance has been more and more eroded. So you're just opening the door for the Trump administration to walk in and boss everyone around. And if you challenge it, they say, well, gee whiz, you let the Obama administration do it, and that's different. And quite honestly, last March, I think it was, the Trump administration, put a freeze on all of our federal research, $1 billion. And that was unfair, but it was obviously to pressure us. They claimed they were fighting anti-Semitism. No one has shown any anti-Semitism. I mean, in terms of proving it. I hate anti-Semitism. Everyone in this room hates anti-Semitism. But do you really want to flush the university down the financial drain in the name of anti-Semitism? It doesn't make sense. And the federal government is putting weird pressures on universities. And so if Day Hall, because of wanting to avoid more of that, acts in a way that's suboptimal, how can I say you're doing it completely wrong and there's this different way about it? Sure. Any other questions? Okay, well, there's plenty of pizza in the back. I do want to, first of all, thank our sponsoring organizations. We've got the Cornell College Republicans, we've got the Cornell Review, Cornellians United for Free Speech, and the Cornell Political Union, and we really appreciate all their support. I want to thank our panelists. Brandon's gone, but we've got Professor Johnson, Professor Claremont, Meta, and Professor Benzel, and I think they deserve a round of applause.